My name is Elizabeth Doherty, and I am excited to be your presenter in this Path to a Patent Part 2, Drafting Provisional Patent Applications. I hope many of you attended the first part of Path to a Patent and anticipate being with us throughout the entirety of this series. This really is a soup to nuts learning opportunity for you who are looking to file a U.S. patent application. Again, my name is Elizabeth Doherty, and I have the pleasure of serving as a regional outreach director at the U.S. Patent and Trademark Office. Today on the webinar with me are two of my delightful colleagues, Hope and Ray, and they are going to be helping address questions in the chat. And if there's any that we don't get to, we'll try and get to them at the end if they're not answered during today's webinar. Again, thank you for your patience as we are starting a little bit late. We had some technical difficulties, so I appreciate you hanging in there and sticking around for this great content. We welcome your questions. We welcome your participation. Thank you again for joining us today. So I am going to go ahead and jump directly into these materials. Again, this is Path to a Patent Part 2, Drafting Provisional Patent Applications. Next slide, please. Next slide, please. So let's set a little bit of groundwork here as we begin and jump into talking about provisional patent applications. Let's first talk about patents in general. I wish I could see all of your beautiful faces because I would ask for a show of hands how many of you have ever filed a US patent application or a provisional patent application, or perhaps even have a patent. But assuming that you are all just dipping your toe in the waters of intellectual property, I'd love to let you know that there are three types of patents: utility, design, and plant. And they each protect very different things. Now, a concept which you may have heard or may not, let's introduce it now, is the creation of an IP portfolio. As you are perhaps creating a small business or undertaking some type of endeavor, which is creating intellectual property, you may be creating different types of intellectual property, which will then be positioned into your IP portfolio. And that's true in the world of patents as well. You may be in need of having one or more types of patents: utility, design, or plan. Utility patents protect generally what we think of as inventions: that new toothbrush, that new cellular communication device, perhaps a new bicycle or mousetrap. It is a new and useful process, machine, article of manufacture, composition, matter, or any new and useful improvement thereof. In fact, I'd argue that 99% of the patent applications that are filed today are for improvement patents, where someone is taking an existing technology and building upon that to create something new and better, more efficient, more effective, more fun. And that's the beauty of the US intellectual property system, is that it in fact is the greatest technological repository of information the world has ever known. So that is the design of the system, that we can build upon it. So in addition to utility patents, there are design patents. Patents protect the new and original ornamental design and protect the way an article of manufacture appears. So let's say you've invented that new toothbrush, maybe a toothbrush with heads on both ends so you can brush both sides of your mouth at the same time. Well, obviously that can be protected by a utility patent because it is a new useful article of manufacture, but you may also want to protect the way that toothbrush looks. That would be done using the design patent. So you are in fact creating that IP portfolio, utility and design, covering the same identifiable article of manufacture. Now, plant patents, one of my personal favorites, are protecting new and distinct invented or discovered asexually reproducing plants. Some of the most beautiful patents that issue are our plant patents. They are printed in color. And I know we are on the verge of the holiday season, so think about those poinsettias. Majority, if not the entirety, protected by US plant patents. So next slide, please. Types of patents. Okay, so here we're going to do that deeper dive into what I was whetting your appetite for. The utility patent may be obtained by anyone. And when I say anyone, no one is too old or too young. Um, no one is precluded, whether they are a US citizen or a foreign applicant. Uh, the US patent system is open to everyone, and that's one of the beauties of our system. Anyone who invents or discovers any new and useful process, machine, manufacture, composition of matter, or any new and useful improvement thereof. So what's important here is that they are invented by anyone, by a human being who invents or discovers anything new meaning novel, not heard of or seen before, and useful. There is a utility requirement to filing a US patent application and for receiving a US patent. The term composition of matter relates to chemical compositions and may include a mixture of ingredients as well as new chemical compounds. Examples include a pharmaceutical drug or shampoo, perhaps even a new cleaning product. An example of a machine may be a bicycle apparatus or device. The term manufacture refers to articles that are made or manufactured. Examples may include a tire or integrated circuit. I know this sounds like inherently complicated language, but we're setting it out here for you for your success. So again, those utility patents protect anything made by someone who invents or discovers any new and useful process, machine, manufacture, composition of matter, or new and useful improvement. So let's keep that in mind as we progress forward. Next slide. So design patents, as I've already hinted at, may be obtained by anyone who invents a new, original, and ornamental design for an article of manufacture. Design consists of the visual ornamental characteristics embodied in an article. The subject matter relates to the configuration or shape of the article. I'm going to give you a fun example. The shape of the Coca-Cola bottle, in fact, began as a design patent. Coca-Cola first protected the shape of their bottle for Coca-Cola soda using a design patent. However, incredibly good use of intellectual property protection, they have now transitioned that to being protected by a shape trademark. And we're not going to talk about trademarks today, but just know that there's some creativity in intellectual property. Plant patents, as I said, protect anyone who invents or discovers and asexually reproduces any distinct and new variety of plant. These can be fruit trees, they can be ornamental bushes, a wide array of subject matter, but our smallest area of filing. Now, I think it's important to note that these different types of patents, utility, design, and plant, last for different durations. The utility is good for 20 years from the date of filing, just as plants, good for 20 years from the date of filing, and design patents are good for 15 years from the date of issuance. Next slide, please. So what is the path to a patent? Well, as those of you who are beginning the process probably know, it starts with a new idea. And that new idea is oftentimes someone trying to solve a problem. Now, that problem may be something that they are experiencing, someone in their family, someone in their community, or perhaps the entirety of the globe. Inventing is really all about problem solving. And thankfully it is, because that's how we are solving some of the world's greatest challenges. Now, when one seeks a US patent, one can file a provisional patent application, and that's the subject matter we're discussing today. But keep in mind that provisional patent application is not a required step of the path. In order to receive a US patent, one must file a non-provisional application because that is what is examined by a US patent examiner. That is what can result in a US patent. The provisional patent application, as you're about to find out, is a 1-year placeholder, but it's an incredibly valuable tool. And I'm glad you've joined us today to learn more about it. One of the benefits, and you can see it here from this timeline because it's laid out very beautifully, one of the additional benefits of that provisional patent application is it can in fact add a year to your patent term in a sense because it begins protecting you from the date of filing. But keep in mind that provisional patent application, it is an application. It can be not be used as an enforceable tool per se. It is only when you have that US patent in hand that you have something that is enforceable against an infringer, against a competitor. So keep in mind your ultimate goal is the US patent. Next slide, please. So what are the benefits of a provisional utility application? And there's many of them. It provides a 12-month window to file corresponding non-provisional patent applications or one application. Sometimes people will file multiple provisional applications, combine them into one non-provisional. It is a 12-month window, or it is a 12-month placeholder, as we like to say, which has you get your foot in the door at the US Patent and Trademark Office. It lets you begin to use the term patent pending. Allows you to begin talking to others, whether those are potential customers, potential funders. It allows you to begin talking to them about your idea with something on file with the office that can form the basis of what we hope results in a US patent. So it provides the time to investigate market potential. You want to know if there's somebody out there who's interested in your widget, whether it's a toothbrush, a mousetrap, or a cellular communication device. You want to make sure, in fact, that once you commercialize that patented technology, that there's going to be someone out there to buy it. It provides time to obtain counsel if desired. Now, you can use a patent attorney or patent agent to file your provisional patent application, not required by law, but many people do in order to get it right. We do want your filing of a provisional patent application to be a thorough filing. I don't want it to be just, notes written on the back of a napkin, because that's not going to do you any good. That's not going to create the firm foundation that you are going to want to have if particularly you are going on to that non-provisional patent application. So it is not required to have a formal patent claim, oath, declaration, or information disclosure. This is what makes filing the provisional patent application arguably easier than filing the non-provisional patent application. This is a lower cost of entry, a lower barrier to entry, and an easier access to getting on something on file with the US Patent and Trademark Office. So with this in mind, this is why people sometimes file this without the assistance of an attorney or agent, and particularly when they're up against a time deadline. Perhaps you're going to a trade show to show your product. Perhaps you are going to do a poster session where you're going to talk about your technology. Before you make these public disclosures, think about filing that provisional patent application. Because remember, again, you do not have to have a formal patent claim, oath or declaration, or information disclosure. So lower bar of entry. Next slide, please. So some of the additional benefits, and like I said, there's a lot of benefit to this provisional patent application. The patent term is measured from the filing date of the subsequent non-provisional application. So the patent term for a utility patent is currently 20 years from the date of filing. So by having that provisional patent application, it provides an additional 12 months of protection. So effectively giving you a 21-year patent in a sense. The term patent pending is allowed to be applied. So the minute you have something on file with the office, whether it's that provisional patent application or the non-provisional, you can use the term patent pending, but that provisional patent application is that easiest way to begin to use that term patent pending. Next slide, please. So what are the filing requirements? And this is where people get challenged. And it's because the intellectual property system is governed by laws and rules. And these have been established over time. Keeping in mind our first patent law was issued in 1790, the same year we issued the first US patent. And these laws have grown and changed and modified over time, but there is some complexity. The US Patent and Trademark Office issuing you a US patent is issuing you a federal right on behalf of the federal government. So knowing that there is that weight to bear, there is a certain level of complexity of this. So what are the requirements for filing a provisional utility application? And keep in mind, these differ from filing the non-provisional patent application. The filing requirements require a detailed written description of the invention. We call it a specification. And that specification should include several sections: the background of the invention, the summary of the invention, drawings describing the invention if the invention can be depicted in drawings. We know not every invention can be depicted in drawings, and a detailed description of the invention. So whether you're filing the provisional or non-provisional, this information is key. This is where you are going to infuse your application with your knowledge of your invention. You are going to describe it with such specificity that others can make and use your invention. And that is what is required by law. You can't hold back. If you are going to seek to uh, be able to prevent others from making, using, importing for sale your device without your permission, you have to disclose it in such specificity that others can make and use it to allow you to obtain that limited right to exclude others. And then, of course, there are filing fees. Now, these filing fees are minimum compared to the non-provisional fees, but there are fees. And that's because the U.S. Patent and Trademark Office is a fee-funded agency. So we charge our applicants the cost of what it costs us to do the work at hand, whether that is evaluating the application upon receipt, whether that is conducting a prior art search, whether that is actually conducting the examination. We charge you based upon the time it takes to do that work. Next slide, please. Filing requirements continued. You didn't think we were done, did you? We need to know everything about you and your invention, the title of the invention. Keep in mind the title of your invention should be a succinct technical title. It shouldn't be Elizabeth's brand new super spanky toothbrush. It should be something that is a technical, concise title. The names of the inventor's residences, correspondence address, attorney information, if applicable, if you have chosen to use a patent attorney or patent agent, U.S. government interest or ownership, if applicable. If you have done this work through collaboration with a government entity, that must be disclosed. And then use of the provisional application cover sheet. This is how we are clear to know that you are filing a provisional patent application with the office. Next slide, please. Here is what the cover sheet looks like. And again, all of the USPTO forms can be obtained from our website, www.uspto.gov. By using the USPTO forms, you are helping to ensure your success in filing and in prosecuting your application. Whether it's a provisional patent application or a non-provisional patent application, using the designated USPTO forms helps both you, the applicant, and the U.S. Patent and Trademark Office being able to most efficiently address and handle your application. So find these forms on our website. Next slide, please. So just showing you some of the information that is required in the cover sheet, again, the names of the inventors. And it is important that you, in deciphering this information, you determine who is truly the inventor, who is the inventive entity, who has contributed to the inventive concept of this invention, because they do all need to be identified. You don't want to get down the road in your non-provisional application or with your patent in hand and have someone question the inventive entity. Next slide, please. Again, doing a closer analysis of the cover sheet and all of the information that's required there. Correspondence address, the firm name or individual if you have an attorney or patent agent helping to represent you, and then identifying for us all of the parts of your application that you are supplying. And this is where we will help do a check when those documents are all received to ensure that you have uploaded them properly. So please let us know what you are including as part of your application. The application data sheet, if using one, the drawings, the specification, any other things, including the number of pages of your specification. And then also identifying the method of payment of your filing fee and if there is an application size fee being required. Next slide, please. The provisional patent application cover sheet again provides information that this goes to the question of whether or not you participated in any type of support from the government, either in a government contract or with an agency of the United States. Remember, that must be called out. And then, of course, you have to provide your signature, name, telephone number, and the date in which you are filing the application with us to allow us to know who is the inventor, who is the filing person for this application. Next slide, please. Provisional versus non-provisional. All too often when speaking with an audience, I will ask if anyone has a US patent. And invariably, I will have a member of the audience say, oh, I have a provisional patent. I'd love for you to have as a strong takeaway today that there is no such thing as a provisional patent. There are provisional patent applications, and that's what we're talking about today. And there are non-provisional patent applications, and there are US patents. It is the non-provisional patent application that can result in a US patent. Today, our focus is on the provisional patent application. So how does that differ from the non-provisional? Well, the provisional patent application does establish a filing date. You are placing something on file with the US Patent and Trademark Office. No claims are required. As you know, when filing that non-provisional, the claims are the name of the game. That is what sets forth the metes and bounds of your invention, but they are not required in the provisional patent application. You can file them in the provisional patent application, and many do, but it is not required. It is inexpensive. It is not published or examined. It is maintained in confidence within the US Patent and Trademark Office, and it is good for 1 year, allowing you to build and create your non-provisional and also allowing you, again, to talk to others with the beginning of a level of protection, whether you're talking with the buying public or talking with VC funders or talking with people who you need their technical expertise in order to actually make your invention. The non-provisional application, juxtaposed against the provisional, has many statutory requirements that have to be complied with in order for a successful filing. It is more expensive. It is published at 18 months from the earliest filing date. It is examined by one of our over 9,000 trained engineers and scientists who serve as US patent examiners, and it can result in a US patent. Now, keep in mind again, the utility patent is good for 20 years from the date of filing. And by using this provisional patent application, you can add an extra year on that. Next slide, please. So here are the fees. So as you can see from this chart, the provisional filing fee, and in fact, a majority of our fees in patents are broken down across 3 fee entity categories. So when you file with the US Patent and Trademark Office, as you are beginning the process, you need to identify, or your patent attorney or patent agent can help you do so, identify what type of an entity you are. What type of a filing entity? Are you a large entity, a small entity, or a micro entity? And this is significant because they pay different fees. And as you can see, they ramp down towards the micro entity end. So if you qualify as a small entity or a micro entity, you certainly want to pay those reduced fees from the very get-go. So know what kind of an entity you are. So what constitutes a large entity? It's a company of over 500 employees. So keep in mind companies like IBM, Amazon, Qualcomm. What is a small entity? A small entity, as set forth by the Small Business Administration, is a business entity of under 500 employees or a nonprofit. The microentity uh, is someone who qualifies as a small entity, but also has to meet several additional criteria. And you can find these on our website, but just in quick order, they are that you have filed less than 4 non-provisional patent applications. You've shown yourself to have some knowledge of the system, um, but you have also filed a certification with the agency that you are in fact entitled to this. Now, as a micro entity, you cannot assign your rights to anyone other than a micro entity. So it's important if you are a micro entity to fall within those guidelines and to know them and to know and appreciate what they are. As you can see, our small entities pay fees reduced by 60%. Our micro entities pay fees reduced by 80%. So it is an incredible savings and one you want to take advantage of if you are entitled to do so. So for the provisional filing fee for our large entities, it is $325. Small entities, $130. Micro entity, $65. Quite a bargain to be had. So again, if you are able to qualify as a microentity, file that certification statement and file it with your application. File it from the very beginning to assure the office that you are entitled to this discount. Small entity, certification statement not required, but you must be able to back up the fact that you are a small entity if ever questioned. Next slide, please. Oh, so here we go, just as we were saying. The small entity status, an individual or small business of less than 500 employees or a nonprofit organization, and must not have assigned, granted, or conveyed or licensed the invention or be legally obligated to do so, who does not also qualify as a small entity. That microentity qualifies as a small entity, has filed no more than 4 previous applications, and provisional patent applications don't count against you, nor do inventions assigned to an employer. An income, and this is what I failed to mention earlier, an income not greater than 3 times the median income, and you have not assigned, granted, conveyed, or licensed the invention or been legally obligated to anyone who exceeds the gross income limit. Next slide, please. So Patent Center. Patent Center is an incredibly useful tool at the US Patent and Trademark Office. The benefits of engaging with Patent Center are that filing and application management are incorporated into a single user interface for enhanced user experience. Patent Center is a platform within the US Patent and Trademark Office, in case you're not familiar with it. It uses the same USPTO.gov accounts and sponsorships that you use to log into EFS Web and PAIR, EFS Web being our filing system, and PAIR being our patent application information retrieval system. The submission of specification claims, abstracts, and drawings in a single docx document without the need to manually separate sections. This makes filing for you much easier. You can file them all together versus individually. Drag and drop interface allows filers to upload multiple files at once. It separates submission and payment receipts clearly to confirm the status of submitted documents and successful payments, which is important because you don't want to miss a document deadline, you don't want to miss a payment deadline or not pay the requisite fee, because these things can delay the processing of your application. What you don't want to have happen is to have to receive a notice to file missing parts or a notice of incomplete application. The training mode is an interactive simulation where you can safely practice filing docx and PDF documents. Incredibly helpful just to make sure you're doing it right. And it is staffed by a team of individuals who are there to help you to ensure your use of Patent Center. Next slide, please. Support and resources. And the USPTO has many, because we are here to help you. We are invested in your success. Next slide, please. Accessing our free services. There we go. My favorite four-letter word, FREE, free. And we have a number of free services through the US Patent and Trademark Office. And unfortunately, many of them are unsung heroes. So I'm excited for you to know that you can find these on our website and know that there is a number of them. This is available from our USPTO.gov website. And if you just type free services into the toolbar, you'll be able to land on this page, which is kind of a one-stop shop listing all of the free services through the USPTO. As you can see, there's 46, 40 of them are within the patents domain, 28 within the trademarks domain. So you're going to want to check out all of them, depending on whether you're pursuing a patent or a trademark, or perhaps both as you create your IP portfolio. Next slide, please. Resources in your area. I'm happy to share with you that the USPTO, while its headquarters is in Alexandria, Virginia, we also have a footprint across the nation. We have regional offices in Detroit, Dallas, and San Jose, as well as a community outreach office located in New Hampshire. Now, sadly, we have recently closed our Denver regional office, but I suspect that will be replaced with some community outreach offices in the not too distant future. It seems to be a working model that we are leaning towards. These facilities of the USPTO are an arm in the community, providing resources, education, information, and engagement. So feel free, particularly if you are located near one of these offices, to stop in, to reach out, to give a call, and ask for assistance. That's what we're here for, and we're happy to help along the way. Um, when you go to our state resources page like this, you can select any of the states within the United States, and you will be provided with a link to additional resources, including the Patent Pro Bono program, which covers that state or region, the law school clinics that are located in that state or region, patent and trademark resource centers that are located in that region. And our patent and trademark resource centers are one of my most favorite things. It's a network of over 100 libraries located nationwide where there is one or more trained librarian trained to assist you in conducting a patent or trademark search. Now keep in mind, patent and trademark searching is not required prior to filing an application. However, it's strongly encouraged because your idea may be just so great, someone's already thought of it. Next slide, please. The US Patent Pro Bono Program. Always super excited to talk about this because this is a resource which provides such great value. As a result of the 2011 America Invents Act, Congress directed the US Patent and Trademark Office to ensure that financially under-resourced inventors were not leaving uh, inventions on the garage workbench or the kitchen table because they were financially under-resourced. So the USPTO at that direction went out and has collaborated with legal organizations across the nation to stand up state or regional patent pro bono programs. These patent pro bono programs offer free or reduced cost legal services to applicants, and they're doing remarkable work. In order to be eligible, we encourage you to look in the patent pro bono program that is in your state or region, although some programs accept applicants from outside of their state or region if they are being underutilized. In order to qualify, three basic requirements are that there is a household income below a certain threshold, knowledge of the patent system obtained by either taking an online course through the USPTO.gov website or filing your own provisional patent application pertinent to today's conversation. And you must have an invention, not just a mere idea. And this is because these resources, while incredibly valuable, are limited. There are a limited number of attorneys participating in the program, in a number of opportunities for pro bono assistance. So we want them to truly be for that inventor, innovator who is looking to start a small business and grow an industry out of their patented technology. Next slide, please. The USPTO Law School Clinic Program. This is another beautiful opportunity bringing resources to financially under-resourced applicants. As you can see from the graphic here, there are law schools across the nation that have stood up law school clinics helping to grow the next generation of IP practitioners. These law schools participate either in the area of patents or trademarks, or sometimes both, in providing services to applicants in their region. The qualifications are set forth by the respective law schools, but closely mirror those of the patent pro bono program. I would encourage you to look at the law school clinic that is in your area as a resource. Next slide, please. Last but not least, I know we're getting to the end of our slide set here and the end of our time together. And I'm excited to see all of the great questions that are coming into the chat. And I want to give a shout out again to my colleagues, Hope and Ray, who have been fast and furiously answering those questions. This list of resources provides you with spots on our USPTO website that can provide you with additional information as you begin the adventure of filing your provisional patent application or just investing in the process itself. We do have a provisional patent application filing guide that you can find. We do have information on the patent process itself. The patent process overview really takes a look at what happens at each step of the process. What can you expect when you're expecting that patent? How does that process go, and how can you best engage with the office? The Inventors Assistance Center is a center that is staffed by remarkable individuals, many of whom have had a 30, 40-year career at the U.S. Patent and Trademark Office, who are available to answer your questions by phone or by email. And again, they are incredibly skilled individuals who welcome your questions. The Pro Se Assistance Program exists for those of you who choose to go the road alone and not use a patent attorney or patent agent. Additional resources and help is available through our Pro Se Assistance Program. For those who are looking to better understand whether you qualify as a small or micro entity, that can be found on our Patents Apply Save on Fees page. Doesn't want to save, particularly in today's day and age. We do have a video for the Patent Pro Bono program that can help you discern whether or not you qualify and what exactly are the resources available through the Patent Pro Bono program. Our Law School Clinic program can be found on our website as well as on our state map. You can find the one that is in your location. A glossary of IP terms. I know when we start talking about intellectual property, particularly in the area of patents, there's a lot of terminology that may not be common to you, or it may not sound as something you have engaged with before. Take, for example, the term prior art. I know in the patent practice, patent examination, we oftentimes use the term prior art. What does that mean? So that glossary of IP terms can be a great way to get your feet wet and better appreciate the language of patents. And then, of course, patent FAQs. Somebody has probably thought of that question that you have, or maybe your question might become an FAQ. We do also have a helpline at the USPTO, 1-800-PTO-9199, and that is a direct into the USPTO. They will direct your call to the area of the U.S. Patent and Trademark Office best able to answer your question.